Well, hello and welcome back to uh, my channel. My name is Joanne. I am the Learner Lawyer. If you've not been here before, welcome to my members and my subs who are returning. Welcome back. I jumped on board because I discovered that there was a response to the Chrisley matter, and I thought, I've just jumped out the shower, getting about my day, and I thought, let's have a look at this. I've not looked at them yet. I just thought it was filed. So let's see if we can make sense of it. Hello, Angela. How am I doing? I'm doing okay, but I'm still I'm suffering from a little bit of shortness of breath, a little bit of asthma. COVID seems to have triggered my asthma a little bit. So it's a wet, rainy day in Melbourne, although the sun start trying to come through. So yes, so I wanted to look at the response that was filed. Now, if you've seen what's been going on in the Katie Joy world, you often know when there's a filing about, because of, there just seems, in my opinion, there just seems to be some outlandish behavior. And I think that we've seen some of that recently. So I thought I would have a check and go, let's have a look and see what's going on. And sure enough, there was a new filing. So let's have a look at this. I believe that there is still nothing in the 7M. There's been no decision made, but look, that can take ages. So we've got, this is a memorandum. Yes, I've had coffee this morning. This is a memorandum of law in opposition to plaintiff's motion to dismiss. So this was filed on the 7th. So this is just this was filed. Oh, this is just dropped. Oh, well, it's the 8th in my part of the world. So it's Friday. So this is, so for this one, it's got Chrisley plaintiff, Catherine Paulson, without a crystal ball, and versus 7C third-party defendants. Now, remember, in this matter, in the counterclaim, Katie Joy is the plaintiff and Chrisley is the defendant. So this is where it gets really confusing. In the original motion, in the original claim, you've got Chrisley as the plaintiff, Katie Joy, and without a crystal ball, as the defendant. In this matter, because Katie Joy has filed the counterclaim, she's the plaintiff, Chrisley's the defendant. So this is where it gets really confusing, and this is where you've got to, where you're going to be. So while the original one says that Chrisley's the plaintiff and Katie Joy is the defendant, because we're dealing with a counterclaim, we're in reverse now. So this memorandum is submitted in response to plaintiff's motion to dismiss counterclaims. Defendant Paulson has properly pled each of her claims against plaintiff. Defendant, oh, they didn't swap them around. Okay, I thought, because I know in the Chrisley one they swapped them around. That's interesting. It's confusing, right? So this is. So they've responded, okay? So remember, Katie Joy filed her counterclaim. Chrisley responded. This is the response to that. All right. So this is in response. I might just make this a little bit bigger if I can, just so that you can read along. It's 5 pages. It's not as substantial as the other one. All right. So pleadings that fail, so this is their legal standard. Pleadings that fail to state a claim upon which relief can be granted must be dismissed. Again, you'll see that they'll quote lots of legislation, lots of statutory provisions, lots of cases. As I said the last time, is that both sides can state the same case for their argument. It's up to the court to decide which argument has interpreted it correctly. And, this is where the fun is. And as I said, I don't know whether it's going to be legal arguments. I don't know whether it's going to be I don't know how, if it's going to be written legal arguments or oral legal arguments. It's going to be interesting because I don't know much about how it works over there, but we're just going to read this. So, pleadings that fail to state a claim upon which relief can be granted must be dismissed. A motion to dismiss tests the legal sufficiency of a complaint. When determining a motion to dismiss, the court takes the facts alleged in the complaint as true. On a motion to dismiss for failure to state a claim, the district court may consider only the complainant and the documents referred to in the complaint. A complaint states a claim for relief if it is fairly gives notice of the claim and is sufficient to permit the application of the doctrine of the res judicata. Okay, so let me just for your understanding, I'm just going to pull this up. Res judicata, so let's have a listen.
Res judicata.
Sorry, res judicata. A matter that has been adjudicated by a competent court and therefore may not be pursued further by the same parties. So, complaint that states a claim for relief if it fairly gives notice of the claim and is sufficient to permit the application of the doctrine of res judicata, which we just saw was the meaning that if a court's already done it, it can't be brought again. All right, so comment on that paragraph. From my recollection, and I'm happy to be corrected, other than stating what was allegedly said by the Chrisleys, there was no evidence that was submitted to show that it was true. So, in my opinion, and as I say, I know Minnesota does things differently, but a copy of the transcript of the podcast with the sections highlighted would have shown evidence. So while they say that the district court may consider only the complaint and the documents referred to in the complaint. Well, I don't believe that there were any documents referred to in the complaint. But anyway, for the purposes of the court, everything that Chrisley says in his complaint is true. Everything that Katie Joyce says in her counterclaim is true. For the purposes of the motion to dismiss. All right. However, the court is not bound by legal conclusions stated in a complaint when determining whether the complaint survives a motion to dismiss for failure to state a claim. Furthermore, in the complaint, a plaintiff must provide more than labels and conclusions. A fair claim is sufficient against a motion to dismiss for failure to state a claim if it is possible on any evidence which might be produced consistent with the pleader's theory to grant the relief demanded. Now, what's really interesting is that some of what they're arguing here is the same stuff that Chrisley argued in his response to motion to dismiss. So on any evidence which might be produced. All right, so the argument. Paulson's defamation claims are pled with sufficient specificity. Oh, yeah. Paulson has set forth a claim for defamation per se. Minnesota is a notice pleading state and does not require absolute specificity in pleading, but rather requires only information sufficient to fairly notify the opposing parties of the claim against it. Under Minnesota law, the pleading of broad and general statements that may be conclusionary is permitted. A pleading will only be dismissed if it appears to a certainty that no facts which could be introduced consistent with the pleading exist which would support the granting of relief. Hello, Holade, but the fact that KJ stated TC said she doesn't have God, which is a protected statement. The rest of her claim is her defamed me, and of course, me stress and gave no example, can't defend the unattained. Yeah, that's correct. Well, actually, I know that the TC said, Todd said that she doesn't know God. She doesn't have God. How many times has she said that she's an atheist and she doesn't believe in God, though? Technically, for him to say she doesn't have God is actually a true statement, to be fair, because she said that she doesn't believe in God. So, Holly, yes, while it is a protected statement, the fact that he has said that she doesn't know God or she doesn't have God is actually true, because how many times has she said it? That she's an atheist and she doesn't believe in God. So this is is that so anyway, the elements of common law defamation in Minnesota are: A, false statement was made to someone other than the plaintiff, and the statement tended to harm plaintiff's reputation and lower them in the estimation of the community. Now that's interesting, because here's the thing. Question for you: did anything that Todd Chrisley say lower your opinion or standing of Paulson? So she is saying that the statements that Chrisley made were false, that they were said to people other than the plaintiff, and that they lowered her reputation in the community. My question to you is, did what Todd Chrisley say lower your opinion of Katie Joy? And that's what the court's going to look at. Statements that are defamatory per se, if they are false, accuse a person of a crime, of having a loathsome disease, or of unchastity, or if they refer to improper or incompetent conduct involving a person's business, trade, or profession. So that's what the Minnesota courts have just stated, that they've defined what defamatory are. So again, has Todd Chrisley done that? So we've said that the common law so we're looking at, so for it to be proven to be defamation, all right, the elements that they need to be shown, that the false statements were made to someone other than the plaintiff, and that the statements tended to harm plaintiff's reputation and lower them in estimation of the community. So my question to you is, do you believe that the statements Chrisley made about Katie Joy were false? So we can prove element 2 because they were made to people. But did your opinion or did they lower what you thought of Katie Joy? And it says statements are defamatory per se if they falsely accuse a person of a crime, of having a loathsome disease, or of unchastity, or if they refer to improper or incompetent conduct involving a person's business, trade, or profession. So my next question to you is, that is the defamation, that is a definition of defamation per se. And again, has what Chrisley said met that requirement? So these are the things these are the things that need to be shown. All right. With regard to false accusations of a crime, there are posts by KJ going back years of her accusing various people of ruining her reputation. She can't pin her bad reputation on TC. Her reputation was ruined by her own actions. That's right, Holly. So that is what Chrisley will need to show. I don't know how she can pin it all on Chrisley. So with regard to false accusation of crime, the words need not carry upon their face a direct imputation of a crime. It is sufficient that if the words spoken in the ordinary acceptance were naturally and presumably understood in the connection and under the circumstances in which they are used to impute the charge of a crime. The Longberg Court went on to state that the test is not whether the speaker intended to make an accusation, but whether a reasonable person under similar circumstances would understand the statement as making an accusation or imputing criminal misconduct or another. Paulson has pled each of these elements. Paulson has also pled facts which support these elements. Weighing each of the factual allegations as true without requiring absolute specificity in the pleadings, Paulson's claim for defamation per se succeeds. With sufficient facts and allegations to support the claim of defamation pled, Paulson's counterclaim contained a legally sufficient claim for relief. Therefore, Chrisleys' motion to dismiss is improper and must be denied. What I will tell you is that this is going to be argued to, this is going to be long and drawn out. That's my opinion. Chrisley's conduct was extreme and outrageous, supporting the claim of intentional infliction of emotional distress. So now we're going to find out what other elements that need to be proven to show that Chrisley caused her emotional infliction of distress. So intentional infliction of emotional distress has 4 elements. So these are the elements. The conduct must be extreme and outrageous. The conduct must be intentional or reckless. It must cause emotional distress, and the distress must be severe. So again, my questions to you are, was Chrisley's conduct extreme and outrageous? Was the conduct intentional or reckless? Did it cause emotional distress? And was the distress severe? Extreme and outrageous conduct is conduct that is utterly intolerable to the civilized community. Conduct directed at a third person can be also the subject the actor to liability if he intentionally or recklessly causes emotional distress to a member of such a person's immediate family who is present. Now, Chrisley's own conduct, statements and directions to his followers is extreme and outrageous, has encouraged further extreme and outrageous behaviours. 2 specific allegations of this extreme and outrageous conduct are Chrisley's calls for others to bring lawsuits to Polson and Chrisley's incitement of others leading to swatting of Polson's family residence. I must be under some rock. I must be under some rock. Can someone tell me when Chrisley told others to sue Katie Joy? He did say that others were looking at suing Katie Joy, and calling for people to contact his attorneys is not outrageous conduct. That's what happens because they want to get, when they go to damages, they need to prove that this is behavior that has continued before. They just want to get their case here. And I don't recall ever hearing Chrisley inciting others to be. Now, it's interesting. It's interesting. How many times has Katie Joy said she's not responsible for what her followers do? And so if someone has said something, so if I had a beef with somebody and then you as one of my followers decide to do something about that, that's not on me, in my opinion, because I've just told you of a problem I've got. If you decide to take action, if I'm not aware that someone's done something, look, there was something that happened the other day and somebody was going to do something. And I said, please, I don't want you to do that. And so they haven't done it because I didn't want to be put into a situation where I knew that something was going to happen. But if I know about it, I will stop it. But I don't, I mean, what is this incitement of others? Please explain. Anyway, she has now accused around 5 other people of having her swatted. I believe someone looked up her police station's weekly actions at the time she claimed swatting. Okay, interesting. And the interesting thing is, hello, Kino, I'm hoping 7M is following this story, because following these filings, because again, when they get to one of the things they can say, well, I know in September no one was swatted in her area. Wow, that's interesting, Holade. For me, I know that you can't refer to other actions, but you could definitely say, well, we kind of swatted this person because she's accused other people of swatting. But anyway, so unlike naming a slag cause examples of threats of legal action which are not sufficient to constitute extreme or outrageous conduct, Chrisley did not threaten to initiate a single lawsuit or call the police to report an alleged crime. He threatened to bury Miss Polson with lawsuits, taking steps to encourage not only family members of her family to individually sue her, but encouraging listeners and others to bring lawsuits against Postal. Now, if I also remember right, I mean, that's not what he said. Chrisley took his call to action beyond mere encouragement and words and went so far to set up a dedicated email address requesting information from others in this pursuit. I don't believe. Now, interestingly enough, that was his lawyers that did that. If I remember rightly, his lawyers were the ones that were handling all of that. So I don't know. While a threat of legal action from one individual to another is not outrageous, using one's position and platform of celebrity to incite extensive legal action against another is shocking and outrageous. Furthermore, using his position of celebrity and influence through his media platforms, Chrisley incited and encouraged others to join in a campaign against Poston that caused distress not only to her, but to her husband and minor child. Social service reports and calls to the police resulting in Poston's house being swatted have resulted in severe emotional distress for Poston and to her immediate family who were present. These types of reports and activities are dangerous to all parties and are utterly intolerable to the civilized community. I would like to see the reports myself. Poston has pled specific facts and allegations sufficiently supporting each of her counterclaims against Chrisley. Because she's met the pleading burden, Poston's claims must be allowed to continue. For the foregoing reasons, Poston respectfully requests the court denies Chrisley's motion to dismiss. Now, what's really interesting, that's only 5 pages. Chrisley had a 16-page memorandum and then supported that with an affidavit with lots of evidence to show that they tried to do it. They've done a 5-page responsive, and then there's been an acknowledgement of service. So what do you think? What are your thoughts on this? They've just gone, I mean, from my point of view, they've just gone, well, everything that we've said's true, because it has to be true under the law. I'd like to. I think KJ thinks in Discovery she'll get access to contents of the email address, but since his attorney ran the email address, he's privileged. Well, she claims CPS visits during Tardy's lawsuit. She claimed lots of. This is the thing. I mean, my issue is when it gets to. Let's just say it gets to costs. Let's just say Chrisley wins and it gets to costs. They have so much evidence that she's accused all these different people. I think, in my opinion, she thinks it's she's untouchable. And that's really sad because we know that, anybody can get caught up in lawsuits. Now, interestingly enough, I've just starting my defamation, my section on defamation. It's been really, really interesting because Australia, up until just recently, had separate defamation laws. So you could actually have filed a defamation case in each state and then seen which one stuck. But now you can only do it in one location. And which is interesting. And they're for most parts, they are uniform. So the rules don't change. However, one of the rules that is not uniform, so essentially if one of the parties of the defamation suit is deceased or dies during the case is dropped, except in the cases of Tasmania and South Australia, I think, from memory, they can keep going, but in most cases. However, if you are a party in the lawsuit, so if there's 2 people and one of the parties, either the plaintiff or the defendants, one of those died, the other person can continue the part that's related to them, but you can't have anything to do with the person that's deceased. So it's really interesting scratching the surface of this. But yeah, I think she's going to be talking about how great Discovery is going to be. Yeah, Discovery is going to be because there is so much evidence that we know that there are issues. of things she said. As I said, I don't really, to say that she doesn't know God, I don't think that that is a really strong case. But again, as I said, she stated she doesn't know God. She's an atheist. She's stated that time and time again. She's got no interest. And it's going to be quite easy for that to be proven. And yeah, again, by her own words, she has said. So I just have some issues with the examples that she's given. But yeah, I'd like to be interested. I'd be interested to see. I want to see the evidence of the. Well, I want to see the police reports. That's what I would like to see, to prove that she was. I would like to see evidence that she was swatted during the Todd Chrisley time. Is that around the time that she talked about the fact the police came looking for Brian Laundrie? She was harboring Brian Laundrie. Is that around that time? She's still trying to. Yeah, she's still trying to get out of the lawsuit. Yeah. Well, she's trying to say that. So this is her response to Chrisley's response to dismiss the counterclaim. But what I find to be interesting is many of the same, things that she's used here, Chrisley used in his dismissal. So it's rather interesting. So I'll just show it again. I'll just put it up on the screen for everybody to see. So she stated here, so she's saying that Chrisley's actions. So she's put two allegations of extreme and outrageous conduct. So the one was the email address that Chrisley put up to get people, he said that if there was enough, he would start a class action of people, but he wanted to hear their stories. And I don't believe that that's incitement, but anyway. And then, and the threat that was it here that she doesn't know God. I don't believe that can that has anything to do with it. KJ's clutching at straws. The fact she only served the third party of the counterclaim yesterday when she filed it in May shows she's full of it. She thought TC would go away, but and that's the thing. Remember, she said that once he went to jail, that was it. Yeah, so she said that the fact that he said that she didn't know God was, was bad. And then he's saying that he threatened to bury Miss Paulson with lawsuits, taking steps to not only encourage members of his family to individually sue her, but to encourage listeners to bring lawsuits against Paulson. And the fact he set up a dedicated email request for this. And that he used his celebrity to cause distress to her and but to also her husband and minor child. Social service reports and calls to police. When did social services calls? When did CPS reports come into it? Now she's saying that CPS was called. Social service reports and calls to police resulting in Paulson's house being swatted have resulted in severe emotional distress of Paulson and to her immediate family who were present. Now we're bringing CPS into it. Wow. When? Tell me. Can someone explain it to me? Can someone explain it to me? Maybe some of KJ's followers who are watching this before you dislike my video, before you dislike this stream, maybe you can tell me how this works. And you please feel free to email me the examples where it has been where it was done. This has nothing to do with TC. She's lost her damn mind. Well, says Kino. Well, very interesting. Very interesting. I'm going to end this stream shortly because I want to go back into the I'm going to do another stream on the That's okay, Kino. Because I want to talk about the barrel arrow matter again. That's just got more crazy. Yeah, but yeah, I just wanted to just go through those documents. Well, I really like the way that Chrisleys lawyers wrote that. To me, the one that was just filed was very was simple. There's not really substance in there. That's just my opinion. And remember, I'm not a lawyer. I'm a learner lawyer. That's why this is called the learner lawyer. And everything that I know is based on Australian law. And I don't understand a lot of stuff. And so I acknowledge that. She probably thinks that because CPS visits are technically a joint family. Can't prove that claim, but I believe CPS under court order can. Oh, okay. True. But you for me, you just can't now just bring in and talk about the CPS when you've never mentioned them before, whole aid. Social services has not come up in one filing until this one. You know, you just can't suddenly pull it out of your backside and go, hey, look, maybe she has had CPS visits, but how do you prove who was responsible for that? I thought the person starting with N, the person who we're not allowed to mention that started with N, was responsible for all of that. Now she's put it on to Todd Chrisley. You can't keep changing the the goalposts and wonder why you're getting laughed at all the time. You just can't do it. Oh, the other thing I want to talk about is the fact that Boris Johnson has also resigned from the UK Prime Minister. So I've got some other stuff that I want to talk about. But yeah. But yeah, I just yeah. Well, I mean, are police reports also privileged information? Are they able to get those, or are they public records? And the reason why I ask, and sometimes it seems like I'm asking really stupid questions, is because this stuff in Australia you just can't pull up. You would actually have to, apply. You actually have to apply for records and get court orders and everything. Like you just can't. Yeah. So this is what's got me really baffled at the moment. So. Boring Johnson is a plonker. Oh, come on. He's been a little bit entertaining. One thing you have to say about even ScoMo in Australia, you are up for entertainment. You knew life was going to be entertaining. Like, things have been really boring in Australia because the government's actually been doing stuff. The government's actually governing rather than being ridiculous at this point in time. Who knows? So, yeah, I mean, when you've got a government that's governing, it makes for really boring news. So, well, he might be able to get his hairbrush now, Boris Johnson. Although I do notice there are some similarities between Boris Johnson's Conservative Party and the LNP in Australia, particularly with how they handled the sexual misconduct claims. So I find that to be quite interesting because there were very much similarities, which was we pretend they don't exist. We hope that they go away, and that resulted in the government, the then government being voted out. So Anyway, it's interesting. Anyway, I'm going to end it here because I don't want to ramble on for too long. But yeah, look, for those of you that are watching Replay Crew, let me know what you think in the comments below. To people that support KJ, welcome. Please, hopefully you have watched this video. But look, police reports are public. KJ's local police station publish a weekly report stating what they did on each day and time. No one has ever been able to find anything to show police at KJ's. Wow. Okay. So if you are a support of KJ, I'm more than happy for you to email me proof and everything to change my mind. But at this point in time, as I said, I have not, I've not seen anything that I would say would support her claims. Just with her timeline and everything, I just find it very interesting. Yeah, so if you want to send me the evidence, and I'm more than happy to jump on here and say, hey, this is being sent to me, and I, will say that she's got a strong claim. But at the moment, I cannot see how she can have a claim, particularly when, as I said, the comment about her not having God, I believe, is also opinion, deemed opinion. So I also think that, if opinion can't be defamatory, but the fact that she said that she doesn't have God, or she's not a Christian, she doesn't believe in God, I think that also will go against her when there is actually videos of her saying that. So that's not going to help her, in my opinion. I don't know. This is going to be very interesting, but I think this is going to also be long and drawn out. And as any story on the Duggar seems to be her making her money, she's going to need money for lawsuits. She'll keep the Duggar train going, in my opinion. So thank you for joining me. If you could please hit the like button. If you haven't subscribed, please do. I do all sorts of different stuff at the moment. I can only live stream. I can't pre-record at the moment due to cash flow problem, but that's okay. I'm working on that, but we will get there. We'll get there. And I'll be live again soon. Probably in an hour or maybe straight after this, just to discuss the latest in the Barilaro stuff and the Johnson stuff, because it's all very interesting, particularly the Barilaro stuff, because it's been revealed that another person got offered the job before Barilaro, another woman, and so it's two women that were pushed aside. This story is not going away. Oh, and I also want to discuss the fact that Nick Kyrgios, is in the Wimbledon final. Nadal pulled out the semi-final, and Kyrgios is now in the final, and he's got to face court in Australia in August over some SA claims, which is going to be interesting. So I want to get your opinions on that as well. So anyway, thank you for joining me, and I will catch you again very, very soon. Bye for now.